So what are you teaching there?
I'm teaching post-mortem tax planning, estate tax planning, actually.
Post-mortem estate tax planning. This is after somebody dies.
Yeah, it's basically how to do an estate tax return. We don't like the name, and we're probably going to switch the name of the class to something else that's more exciting, so that we can, I guess, entice more students to come take it. But it's very exciting stuff. I don't know.
So an entire course just on post-mortem tax planning.
Correct.
Wow. And how many cases do we get like that in a year?
Well, I mean, just about any estate that comes through has some sort of a tax aspect to it. Everybody has to file an income tax return.
Right.
And if it's over the exemption amount, you have to file an estate tax return. And so a pretty good part of my class is all about how to prepare the estate tax return, how to go through the probate process, the taxation of trusts and estates, for income tax purposes too. And so it's all about any kind of tax that hits what happens after somebody dies, and how to handle the estate, and how to handle their trusts, how to fund their trusts, and how to do all the compliance work that goes through all of that whole process.
Yeah, and are these undergrad kids or are these professionals that are taking this class?
I'm going to say 90% of them are usually in the postgraduate, the LLM program, which is a master's in law program. But we do have the occasional JD that is usually a CPA who is interested into going into tax, and has just padded their JD degree with a whole bunch of tax planning. Like, I had 19 hours of tax built into my JD. I'm actually a contemporary of our partner, Juan Vasquez. And he went and also put, built in 20 hours or so of tax into his JD. And then he went to NYU and got an LLM on top of that too. So,
yeah, that's awesome. So you mentioned something really interesting, talking about, post-mortem tax planning and how after somebody dies, then the probate process and doing the tax returns and funding trust and so forth. So just to kind of help everybody get the lay of the land here, what happens when somebody dies and they don't have an estate plan?
Okay. Well, if you have a will, you're saying that they don't have a will. So they haven't planned anything.
They have nothing.
Well, then the state of Texas decides where your property goes to. And as long as all of the beneficiaries that are prescribed by the state of Texas in the heirship statutes agree, you can actually get an independent administration here in Texas, and go through the estate administration process just the same way you would as if you had a will. There are a lot of surprises that happen, though. So, for example, if you die survived by a spouse, and kids from a previous marriage, your community property is actually distributed to your children and not to your spouse. And that's a rude awakening for a lot of clients there. And so the heirship statutes are kind of a surprise and a little bit of a shock to some people. So it's kind of my, I guess, goal is to try to make sure that you know where your property is going to. And my job is just to basically make sure that your wishes are carried out and the property goes where you want it to go and not where the state of Texas thinks it ought to go. So.
Yeah. And what does that process look like? So somebody dies and then goes to a courthouse somewhere for probate, right? And then you said there's an independent administrator. So someone's paying for that. It's coming out of the state property, I'm assuming, right? And if there's any money left over, then it gets distributed. Is that a lengthy process here in Texas? Is that an easy process? What does it look like?
It's a pretty easy process, and it is a little bit time consuming. I mean, there's the case where you do have a plan and you do have a will and everything's kind of laid out. We still think that ought to take about 6 months because you're not quite sure who all your creditors are. Usually kind of we figure out where all the assets are if you have a good list of assets, and sometimes that takes a while too. Sometimes you don't find out about assets until you get 1099s that come in the mail. Or you can look at unclaimed property and find assets, too, for somebody that didn't keep a good list of their property. So finding the assets, figuring out what the liabilities are, that can take a good 6 months or so. And sometimes when medical expenses, associated with the decedent's last illness come in, it'll be 6 months later and you'll get some sort of a bill from an ambulatory service or from a cardiologist who treated, the decedent during their last illness. And sick people aren't very good at paying their bills. So a lot of times we like to just sort of let things settle and see if like the bills kind of come in, so we know what kind of assets we have and what kind of bills we have. So we kind of intentionally take our time a little bit.
So let me ask you a question on that. So somebody passes away and the beneficiaries, they say, okay, well, there was this much money that was left to us. They take the money and then later on these bills come in. What happens in that case? So let me give you a more specific example. Somebody's got a life insurance policy, pays out to the beneficiary, and then 3 months later, bill comes in from the ambulatory service, let's say, and the kids have taken the money. What happens then? Can they go back and say, well, wait a minute, we're owed some money here?
Actually, life insurance is one of those creditor protected assets where the life insurance proceeds actually aren't responsible for satisfaction of any of the decedent's creditor issues. The life insurance pass just free to the beneficiaries on file with the life insurance company. And so they're theoretically not responsible for any of those bills. It should be the assets of the estate that are charged with the decedent's final bills.
So what if they have an IRA or they have a brokerage account, like, they have an investment account? What happens then if the kids, let's say in this case, they're the named beneficiary, they take over the accounts and then the bills come in?
Just to back up a little bit,
yeah.
the way that we kind of handle creditors' claims there's sort of a list of claimants. There's a priority of claimants, and it starts with secured creditors get their assets that are secured by. So if you have like a car note, somebody can come and collect your car.
Right.
If they have or if there's a mortgage, on a house, like you can, they have a lien against their house, and all what you usually do is just try to figure out a way to get the mortgage assumed by the surviving spouse, or you refinance it if you need to do that. But the way that you handle kind of creditors' claims are sort of in the order of priority. There's a situation where some of the creditors don't all get paid. If, and one of the kind of the first rules of, in probate is that you're not supposed to inherit somebody's debt. So that if the estate is approaching insolvency, you just sort of have to pay the creditors in the order they come in, sort of like you would administer a bankruptcy estate. If there's only so many assets, you pay, those claims. But the proceeds from life insurance and the proceeds from an IRA are all exempt from creditors' claims. Now, joint accounts, they're not probate assets, but I think a creditor can reach those joint accounts even though they don't go through the estate. That's sort of a secondary way to get to those assets. And there's a whole kind of process that you go through, both in an independent and a dependent administration, just to kind of handle creditors' claims.
Yeah. So we've been talking up to this point about somebody dying without a will.
Okay.
But what if they had a will? From my understanding, even if you have a will, that doesn't mean it skips probate, right?
That's right. Just to kind of back up a little bit, when I get a phone call from a family member after somebody died, the first thing that I tell them to do is to say, don't call me for a couple weeks. Go write an obituary, write a bunch of thank you notes, have a funeral, figure out, who you need to thank, and come back and see me, and we can actually get a will on file. And what happens is at the funeral home in Texas, they will notify Social Security of the decedent's death. And then once they notify Social Security, somehow or another, all the banks that the decedent has bank accounts with will eventually be frozen, and until you go through the probate process. There's an exception for any kind of account that has a survivorship feature, but generally there's sort of a period of time between the date of the decedent's death and the date that the executor gets appointed to be officially appointed by a probate court, where nobody can actually do business on behalf of the estate. And that's kind of prescribed by law. There's an 11-day what we call posting period, where out in the Old West, it used to be a notice that you put on the courthouse door where they'd say for this next 11 business days, you can come forward if you have claims or if you have an interest in the estate. And then you actually go through the probate process. But kind of during that period, like we just kind of sort of take care of a funeral. And usually if you don't have assets that are in a joint account, sometimes you have to advance those fees to take care of a funeral. So I always try to make sure that my clients have sufficient assets to pay for a funeral and about 3 months of worth of expenses to go through the probate process. That can be a rude awakening too. Funerals these days are about, I don't know, it's $15,000 to $30,000 on average, so that's a pretty big expense.
Well, let me ask you this. So from a practical standpoint and thinking about estate planning, how often do all the beneficiaries of a estate agree on what should happen with the mom and dad or uncles or aunts estate?
Usually they don't have much of a choice. And if there's somebody with a will, they can usually agree on what we call an independent administration, even if there isn't a will out there. And so if you get all the beneficiaries together, everybody sort of can agree that we're going to try to handle this easily, because either the will or the state of Texas decides who gets the property, and it's in everyone's best interest to make sure that that goes smoothly. So they usually kind of elect somebody who can be the administrator of the estate, or the will actually provides who the executor is supposed to be. And the executor is really the person that's in charge of trying to figure out who pays all the debts, who gets all the, how they get all the assets, and just sort of managing expectations of the beneficiaries. Most of the time, like all the disagreements come along with the beneficiaries not being informed very well by the executors. That's the kind of the number one problem that you see with estate administrations, is that everybody's kind of kept in the dark a little bit too much, and nobody knows what's going on. And they've already spent their money that they think they're going to get, and they don't know how much money they're going to get, and they get angry with executors. So it's sort of my job to help an executor get through the estate administration, keep the beneficiaries informed, and keep everybody just happy with the process and feel like they are well informed with when everything is going to happen in the stages along the way. So
now, I've heard this saying before. Tell me if you've heard it. Somebody said that a will is one of the most expensive estate planning documents somebody could get, and the thought behind that is you think you're getting estate planning, but you might not be getting everything you need. And so, can you talk to us a little bit about the difference between somebody having a will and somebody having a revocable living trust?
Okay. Well, a will can be expensive. All it has to do is dispose of your estate, appoint an executor, and frankly, you can do that in 2 or 3 sentences. I mean, you can have a holographic will that's just entirely in your handwriting, that's completely free. And a lot of times, I will have my clients, before they leave my office, just scratch out a holographic will before we actually prepare the professional will. In terms of the decision between preparing a will or a revocable living trust, there's really not too much of a difference in the price for preparing either one or the other. It's the only kind of difference is that, and then in a revocable trust that can have all of the dispositive provisions of a will, you do have to take a little bit more time to actually fund the trust if you're going to fund the trust. But in Texas, probate's easy. Everybody's kind of familiar with Susie Orman and talking about how to avoid probate in other jurisdictions like California, where they charge you a percentage of the estate to go through probate. And there's other jurisdictions around where, like, the probate court gets very involved in everything that you do with probate. Here in Texas, it's kind of like the Wild West. The executors are, if you can get kind of to the point where you have an independent administration, maybe the will provides for an independent administration, maybe the beneficiaries agree that they can have an independent administration. Your executors and administrators just can kind of figure out how to pretty much carry out the terms of the will amongst themselves. And you only have to go through about 6 or 7 kind of basic filings through the probate court, including like filing an inventory, signing an oath, notifying all the beneficiaries that the will's been admitted to probate, and pretty much you're on your own to carry out the will and to satisfy all the gifts.
So when someone's going through that decision tree of, do I need a will? Do I need a revocable living trust? What are some things that, or I guess, what are some considerations that will lead one to one path versus the other?
Okay. Well, I use them interchangeably all the time. The trust is usually a little bit harder to read for clients. And so if you have an elderly client, sometimes I prefer a will because it's a little bit more straightforward. Usually the thing that kind of pushes me over the edge, though, is the type of assets that the client has. If the client has real estate in another state, for example, you'd have to go through a separate ancillary probate in that other jurisdiction, unless you actually transfer that property outside of the state of Texas to the revocable trust. So anybody that has significant holdings in real estate is actually a good candidate for a revocable trust. You also want to keep in mind that wills are public, are basically public record, and you can find somebody's will. So if you ever want to have something private in your estate plan, as you might kind of choose to fund a revocable living trust instead of a will.
Okay, so privacy and complexity of assets. And then what about when it comes to young families with young children, talking about guardianship and directions for their wishes in case something happens to them? Now, if parents make a decision or they put down on a piece of paper in whatever format that, hey, if something happens to us, we want so-and-so to be guardians of the kids, that's not automatically binding, correct? Still up to a judge?
That's correct. So you can have a declaration of guardian for children, which is just a piece of evidence that would come up in a hearing where a court appoints either a guardian ad litem, an attorney ad litem, and they do an investigation of the child's home and to figure out whether or not you need a custodian or a new guardian of the person of the child and a new guardian of the estate of the child. A guardian of the estate of the child would be the person that would take care of the money that belongs to the child, and sometimes the child has a settlement coming in as a result of a personal injury. And essentially, you want to make sure that anybody under the age of 18 isn't in a position to receive money outright, because they can void contracts. They are voidable, and they don't have contractual capacity. So kind of what my job is to make sure that the state of Texas doesn't get to dictate how that property comes to the minor children. We use a series of trusts. Usually they're kind of in the back of the will. Sometimes a court can create a trust if you don't have one actually in a will, but that's a very important kind of part, is designating who your guardians are, and making sure that you understand who's going to take care of the kid's money and who's going to take care of who's going to have custody, who's going to be guardian of the person of the child. But when you designate who that is, if something happens to the person that you've designated as guardian, maybe you've designated a parent and that parent has had a stroke and is now wheelchair bound and is not exactly in a good position to take care of a 3-year-old, for example, a court is going to do an investigation and they're going to actually look at the facts and circumstances surrounding the situation. And if it's not a good fit and things have changed since you filled out your declaration of guardian for kids, they're going to actually place the kid in the best interest, in a home that makes sense. So you're not stuck with a guardian designation that you don't like anymore. So
yeah. So I got a question for you. So we talked about somebody passing without a will, then somebody with a will, and then we also talked a little bit about a revocable living trust. From a cost perspective, does it cost any more money, or is it a lot easier from a transition perspective if somebody has a trust versus not having a trust? Does it make the transition smoother? Is it less costly, or does it not really matter here in Texas?
A lot of times when we do planning, we'll either build a series of trusts into the will itself. And so it's called a testamentary trust. And in terms of, I guess, the cost, the difference between a tax planned will with trusts that are already incorporated in the will and a revocable management trust that becomes irrevocable on the death of the decedent, the difference in price between those two is negligible. There might be an extra $500 for the trust. Just because there's a little bit of housekeeping to set up an account in the name of the trust and to actually fund the trust with cash assets or even real estate,
Yeah, I guess I was more concerned about post-death when the executors dealing with the estate. Does it make their job easier? Does it make it easier on the beneficiaries if there is a trust in place that they just go on with their lives? There's less administration at that point versus having to deal with somebody passing away with a will or no will at all, and now we got to go to probate.
Well, the beauty of the revocable management trust is that there's already a line of successor trustees that are built into the trust agreement. And to the extent that you actually funded that trust during your lifetime, you don't have to wait that 3-month period in between the date of death and the date that your executor is admitted, that the will's admitted to probate and your executor is appointed, where all the assets are frozen. If there are assets already on deposit in an account in the name of a revocable management trust, the trust agreement itself will kind of provide for the successor trustees to step in the shoes of the decedent and kind of pick up exactly where they left off without, having any delays or any kind of court proceedings to do that. And so it really does kind of facilitate an easy transition. But here in Texas, when we actually set up those revocable living trusts, sometimes we do that without an eye towards actually avoiding the probate process. And so the revocable trust only works to the extent that you funded it. What I usually recommend is that you take a big brokerage account that's not your IRA or your 401k, and you at least put those assets in your revocable management trust so the trustees have some assets to pay claims, to hire attorneys, to pay for a funeral, and for anything that kind of comes up. And eventually what the wills usually say, if you have a revocable living trust with what we call a pour over will, is that anything that's not already in the trust on the date of death was eventually going to be distributed to the trustee of the revocable management trust through after the probate process is finished.
Yeah. So here's a question that comes up all the time when we're talking with clients about estate planning. They'll ask the question, is this something I do once, or is this something I got to do on an annual basis? So talk to us a little bit about trust management or estate planning management. Let's say somebody comes to you, they get their will done or a revocable living trust done. How often should they be looking at that? How often modifications, or what are some of the triggers that would make them want to say, hey, let's take a look at this and see if we need to modify it?
Okay. Well, if you get your estate planned and you get everything in place the way that you want it, we still recommend that you revisit that plan at least once every 5 years. 10, you're kind of pushing it, but and also in events where marriage, divorce, you're having another child, any just kind of big life events. We always think it's a good idea just to come back and revisit, but at least once every 5 to 10 years, we like for our clients to come back and check in with us. And just because of the way that these practices work, we kind of decide that we can't take it upon ourselves as lawyers to inform you of every different thing, every little thing that comes out in case law and statutes. I mean, the tax rules are always changing every year, so we like for our clients to watch the news, but about every 5 years we like for you to contact us and to come back and say, how am I doing? Is this still work for me? Let's go look at your executors and all of your agents and see if we need to refresh any of those. And that's usually kind of, we can make little tweaks, but you don't necessarily need to start over every after 5 to 10 years. And I've signed off on wills that are 20 years old that aren't broken when I don't want my clients to have to incur any additional expenses. So
yeah, so you mentioned tax law changing, which impacts how planning's been done, and obviously over the last 5 years or so, we've had some major tax legislation that has had impact, including one where with the rules on inherited IRAs now, a lot of, bypass trusts, bye-bye, right, from a tax planning perspective. That's just one example. But we have something coming up here at the end of 2025. The Tax Cuts and Jobs Act is about to expire, and the estate tax exemptions are going to revert back, inflation adjusted, to where they were. So it's going to have more people are going to be impacted by potential estate taxes. So right now, it's, what are we, 2023? 2 years out. What should people who are either going to have an estate tax, they're going to fall into the estate tax bracket, or are on the cusp, what should they be doing now in anticipation of the sunset provisions of the Tax Cuts and Jobs Act?
Okay. Well, we're under a sort of use it or lose it gifting strategy right now, where if you're in a position that you have more than $6 million that you can bear to part with, and here's the key, that everybody is worried that they need to start giving away money, but sometimes right now you don't need to hurry up and do that before 2025 unless you're in a position to be able to give away more than $6 million. And the concept here is that the exemption amount that is currently $12,920,000 is going to revert back to that $5 million exemption amount, which with indexing for inflation, like you said, will probably be in the $6 million range come 2026. And unless you are in a position to give away more than six, you don't really need to do anything on an expedited basis. But if you're in a position where your estate is over, let's just say 12 to 15 million, and you can afford to make a gift in excess of $6 million, it really, really makes a difference if you can do it now. And do it while you can, because there is kind of a rule that says that they're not going to claw back. Use it now, or you're not going to be able to use it later. So
Yeah, and I think that came out, I think it was 2 years ago. It was like Thanksgiving. I remember that the IRS put out that notice saying there's not going to be clawback, use it and lose it. And we had a guest in here, a valuation expert, talking about valuation discounts. And we were talking about how there aren't enough appraisers out there if everybody rushes them. What's your take on, I know there's a big push, at least from one side, where they want to do away with valuation discounts. What's your sense on, we're talking about use it or lose it. We're talking about valuation discounts are still valid. That hasn't been taken away by Congress yet. If someone's on the cusp, is this go time right now to try to get this in order?
It really is. And I can't emphasize enough that there are very few professionals out there in the valuation industry that actually understand the gift tax disclosure rules and can put together a professional report. They don't actually just sort of invent these valuations and stick a phantom imaginary discount on top of that. They actually really have to go through a lot of analysis of all the assets in the market and in which they're going through, and for the appraisal to be professional. I can't emphasize enough that basically there won't be any attorney around to represent you if you wait till the very last minute to get it done. So it just behooves everybody to kind of get started on that right now. And not wait till the absolute last minute to get it taken care of. There's also no guarantee that there isn't going to be an interim, law that's passed. I know that it's been a goal of our administration, current administration right now. Even just a year and a half ago, they had proposed a $3.5 million exemption, and that made it through a Senate bill. During COVID. I think that was just 2 years ago. So you never know. I think we ought to just do it while we can. And if you're thinking about it and you think you can afford it, just get your CPA and your financial planner to go run some numbers and figure out if you can afford to make that gift.
Yeah. So what is the tax rate for if you do have to pay a state tax? What's the tax rate on that amount?
Okay. So the tax rate is basically, for all practical purposes, a flat 40% tax on assets over and above the exemption amount. And because this exemption amount is kind of fluctuating so much, it's $12,920,000 this year. It was $12,060,000 last year. And so it keeps going up and down. It's a pretty serious tax, though. It's a tax on the value of your assets, not on the income that's produced from your assets. So you have to be very, very careful. And that's a hard check to write as an executor, if you have to write in a check for the estate tax.
And where I see a problem there with people who fail to plan, they'll say something like, you know what, I'm going to leave real estate because it produces income so my spouse and kids could have that income coming in. Mm-hmm. That's fine and dandy until you need to sell some assets to pay the estate tax, right? Now you got a fire sale. So those assets are gone. So the income's gone, right? I don't want to bring in news from today, but over the weekend, you heard about this one bank having to sell assets that they held to pay depositors, right? So that's a real thing that could happen. And correct me if I'm wrong, Christine, but in a situation like that where somebody passes away with a large estate on paper, it's not liquid, right? Let's say it's real estate holdings, that's income generating property, but now the IRS says, okay, you owe us, let's say it's $10 million above the exemption. You owe us $4 million. Now they got to come up with $4 million. Either got to take a loan or you got to sell some assets, right?
That's correct. There are a couple of ways that if you are the owner of a closely held business and at least 35% of your estate consists of an asset in a closely held business, and that's usually what kind of generates the liquidity issues, you can extend the period for payment over a course of up to 15 years through it's called a 6166 election. But for the most part, a lot of taxpayers don't actually qualify for the 6166 election. So you have to come up with a way to raise the liquidity. And you are writing a check to the IRS within 9 months of that decedent's date of death. And that can be a very big check for a lot of people. So you need to know where that money is coming from.
What about, and correct me if I'm wrong, I understand the exemption applies to U.S. citizens. What if you're not a U.S. citizen?
So if you are not a U.S. citizen and you are a non-resident alien, there is a $60,000 exemption only that is limited, so that you need to be careful about that. If you're not a citizen, but you are a U.S. resident, you are taxed like a U.S. citizen. So for all practical purposes, you have all of the same exemption and the same exemption equivalents as you would as a U.S. citizen. There is a special rule for spouses to get a marital deduction where you have to have what we call a Q dot put in place, and you can either do that beforehand or even after the fact and reform that so you can kind of avail yourself of the marital deduction. And what I'm talking about is a special feature of the estate tax where the IRS has basically said that we don't want widows and widowers to have to write a big check for the estate tax to the extent that the assets of the estate go to a surviving spouse. They're going to wait and actually assess that tax on the estate of the surviving spouse's estate when those assets are supposed to go to children. And that's when you're going to usually see estate tax being paid. It's at the death of the second spouse to die.
Unless there's an event and both die at the same time.
That's right.
Okay. Yeah, it's tragic, but it does happen. We're talking about liabilities of estate tax liabilities, but a lot of folks are also concerned about another type of liability, and that is creditor liability, getting sued. And so the concept of asset protection often comes up with people that have a liquidation event, do an M&A transaction, they've come into money, and now they're like, okay, how do I protect this, not just from my creditors, but potentially the creditors of my kids? And so we're talking about estate planning here, and a lot of times we have these discussions with clients saying, hey, we know you know what you're doing with your money, but are you sure your kids will know how to handle this money? We want you to go talk to an estate planning attorney to help put in some protection. So I want to talk to you a little bit about this concept of asset protection, both in terms of somebody who's got a lot of assets. Let's say, they're still in their working years, but they've accumulated assets. And then also for those that are planning their legacy and they want to protect their children from their children, so to speak. Talk to me a little bit about the distinction. First of all, let's talk about somebody's made a lot of money and their money isn't necessarily in ERISA protected pensions. They, maybe it's in a closely held business, or it's in brokerage account, or it's in cash. What does that look like as far as doing some simple asset, going about protecting those assets?
Okay. Well, on the front end, kind of one of the first parts of my interview is just to kind of figure out what kind of assets you have and how you hold them. So it's all about kind of ownership. If I interview you and you tell me that you are manufacturing dynamite as a sole proprietor, I'm going to actually think about maybe forming an entity so that you might have some limited liability and doing business, under that guise. I want to make sure that you have sufficient insurance. Say, for example, if you're a physician, if you are employed by a hospital, and make sure that you have your malpractice insurance all set up. Or if you're a small business owner, that you have sufficient insurance to kind of cover anything that might happen with respect to the kind of your profession. But generally speaking, in terms of just passive investments, if you hold rental real estate, you've got to be really careful about your own actions. And for example, you can get in trouble for not having a smoke detector up to date in a rental property, or leaving a gate open in a house with a pool and a fence. And if some kid walks in your backyard and drowns, that's a terrible situation. So kind of the first thing I want to do is figure out how you own that real estate, whether or not it's held in an LLC or a partnership or another entity that has limited liability, so that if somebody wants to sue the owner of that property, the owner is not you, and your assets aren't exposed to the extent that you kind of observe all the corporate formalities of those entities. So we like to make sure that you hold real estate, especially residential real estate, in an LLC, and then we kind of take a look at your assets. Are you still working? Are you doing anything that's risky? Are you serving on the board of any charitable organizations or any other organizations too? What are you likely to get sued for? And generally speaking, you don't need a passport to do asset protection planning for the most part. What I like to see people do is just have sufficient limits on their auto insurance, because everybody has a car and a cell phone, and you can be texting people and driving down I-10, hit a car full of doctors and get in a lot of trouble. And maybe if you have a house and somebody falls out of a tree, or workman falls out of a tree, your homeowner's insurance should be able to cover most of those sorts of things. So you just need to make sure that you have sufficient limits on your auto insurance, your homeowner's insurance. And on top of that, I always recommend something called an umbrella policy that you would get through that same kind of policy where they would pick up where the liability limits for your regular homeowners and auto insurance leave off. And umbrella insurance is really pretty cheap. You can get, about $1 million worth of coverage for about $300 or $400 a year. And used to be in many of the law firms that I've worked at, we required every one of our lawyers to carry an umbrella policy just because it was inexpensive, and they don't actually have to cover anything unless we exceed the limits of your homeowners and auto insurance policies.
Yeah, I mean, I think there's this misnomer about LLCs and corporations where they provide you some sort of individual protection, and they do to an extent, but you're always responsible for your own negligence. Just because I have an LLC and I'm driving my car in let's say it's an LLC, or I'm driving in pursuit of my related to my business that's in an LLC. If you crash your car into somebody and you're at fault, they can sue you individually for your own individual negligence. So I always advise clients, LLCs are great idea, but insurance is always the first line of defense, especially because they usually will cover your defense costs. And so if I have an LLC, it doesn't mean it's going to pay for the lawyer that's going to defend the LLC that I set up. So I think there's kind of a narrative or a misnomer out there that, I have an LLC, I'm protected.
Yeah, that's a very good point, because those defense costs could add up. Even if you prevail, you got those costs. But I want to go back to, Christine, you said you don't need a passport to do asset protection, because I've heard people come in, they said, hey, I've heard some, and I call these guys promoters, some promoters pitching some offshore asset protection. And for the most part, as you said, you could do proper asset protection here domestically, right? I mean, even if we go above and beyond, insurance, even if we go above and beyond basic entities, that next level of asset protection, we don't necessarily need to go in an island country somewhere.
That's right. And I guess my experience with the folks that have actually used, the Cayman Islands or gone offshore and used like Bermuda life insurance, for example, a lot of times they're very unhappy with the way that those very expensive trusts operate, and they're just not all they're cracked out to be. They're So I believe that most of the asset protection planning you can do at home. And kind of one of the first things you might want to do if you're worried about liability is pay off your house. Your house is generally a bulletproof asset. Your life insurance policies are usually creditor protected. Your IRAs and 401ks are usually creditor protected. And there's just a list of assets that you can own here in Texas that nobody can take away from you no matter what. Of course, you have to pay your mortgage on your home or else the bank can take away your house. But for that most part, if you get into some sort of a trouble, those kinds of assets are actually kind of the best kinds of assets for you to own. It's only to the extent of the other assets, the assets that aren't in a 401k and our IRA, that we worry about that a little bit. But that doesn't mean that we need to go offshore with respect to those assets. I don't think those offshore trusts work as well as everybody thinks they might. So.
Yeah. And so for our example here, somebody here has a liquidation event, their house is paid off, their pensions are funded to the extent that they're funded, but they have all this cash sitting there in bank accounts or brokerage accounts. They don't have to go to offshore. There are things that they could do here above and beyond insurance and some other planning techniques that are available here domestically that could take care of their needs, right?
That's right. And I can't emphasize more that insurance is really the way to go, the first line of defense. We don't like to get too fancy with a lot of the techniques, but life insurance is kind of a good place to park those assets. As many just other things. Yeah. There's some sorts of annuities that are sometimes asset protected too. And I don't want to get into the specifics too, but I definitely think on a case-by-case basis, you might even set up a little family limited partnership with respect to a whole lot of cash that you have sitting out there. And it might help you, but the family limited partnership and the LLC is not foolproof, so.
Yeah.
So.
Yeah. And just to kind of clarify, like a family limited partnership is just kind of a common term we use. There's no legal term called family limited partnership. It's just a technique, the name for the technique of using business entities for family and estate planning.
Yeah, well, we've talked about this, right? The whole point of asset protection is more of a deterrence, right? It's not ironclad. It's to basically dissuade the other person from having to come after you because they're going to say, oh, it's too expensive. We don't want to go down that route. But I want to pivot now to talk about when a family or a person wants to do some planning for the next generation. They want to protect their kids from themselves or future in-laws and future creditors. What does that look like? I know we just brought up the concept of family limited partnerships, and I've seen that used before.
I have a funny story about this, actually. So I was in a meeting, and we were talking about the family, and it was a wealthy family, and one of the daughters of the family, who did a lot of traveling and stuff, they were trying to do some planning around that, and my colleague goes, well, how old is she? And the client goes, why, are you interested? And it's like, no, we're trying to figure out, because different stages of life, 20-year-olds act different than 25-year-olds, act differently than 30-year-olds, and so on and so forth. And so sometimes an age plays important. No, that was just a funny story.
Okay, Jack. So,
well,
go ahead. Christine.
I mean, I'll just say this: that I'm a tax lawyer first and foremost, and every time they raise the exemption, there's something in the back of my mind that thinks, well, I might be out of a job if there really isn't any more estate tax planning to do. But the one thing that is always going to keep me employed is the fact that there's always going to be a no good for nothing son or daughter-in-law that you want to keep your assets from. My job is to make sure that your assets go to your spouse and your kids, and not your kids' ex-spouse's divorce attorney, so we want to make sure that your assets go to those kids in trust and not to, because that's trust property. It's not community property that can be divided by a divorce court. Separate property can, of course, be commingled, but trust property, at least for an irrevocable trust that is set up by a third party for the benefit of by a parent for the benefit of a kid, or even a parent for the benefit of the surviving spouse, has a lot of creditor protection here. And here in Texas, they really respect the right of a trustee to decide how assets are best used for the benefit of the beneficiary. And the beneficiary can be in a heap of trouble. They can have IRS problems and all sorts of issues. But if you have assets in an irrevocable trust for your kid, only the trustee gets to decide how to spend those assets. And you can't levy against the trust, and you can't force the trustee to compel a distribution if you have a discretionary standard. And so these trusts that we do are kind of my best selling point for my business. So,
well, I think that's a great point that you made, because there are, in situations where you have a happy marriage and your kids are doing very well, and it's like, well, I guess I'm fine. I don't really need it. And then I go, well, what happens when you pass away and your wife finds somebody she likes, and next thing you know, she gets married, and her husband, is interested in having a good time with them, and all of a sudden, you see people kind of freeze up with that idea, and that's what those trusts and those other mechanisms kind of prevent.
Well, I tell all my clients, I hate leaving money to kids outright in form of cash. There's just so many things that could go wrong that it's just a problem. But when we're talking about leaving money in trust for the kids, now up to this point, we've been talking about, the state tax exemption, wealthy families, but this isn't necessarily something limited to wealthy families, right? I mean, middle-class family that is leaving money to the next generation. It's also a good idea for them to explore this idea of not leaving money directly to the kids. Am I wrong?
I have never in my life drafted a will that didn't have some sort of a trust embedded in it, no matter what the size of the estate for my client. And at a very basic level, the first thing you want is to make sure that the probate court judge doesn't get to administer the estate. So if you have minor children, you want a trust in there to at least prevent the children who are under the age of 18 from getting that property, and to pick your own trustee. Above and beyond that, you don't have to have millions and millions of dollars to need planning. We put together these trusts for kids even $1 million worth of assets is enough to protect, so I just can't emphasize how much, a lot of people have this idea that you don't need to do any estate planning if you don't have this large estate and it'll all just sort of be fine. Well, that's all well and good. And it might go to the people that you want it to go to. But when you have an opportunity to protect that inheritance and to make sure that it stays with them by using these trusts, and it's very inexpensive to do so, I would highly recommend at least exploring that option.
Yeah. Well, in the time left here, I'd like to talk a little bit about some of the basic or common mistakes that people make in estate planning. And I think you had brought a list with you to talk about some of those. So you want to share those with us?
Okay, well, I've got a couple things. So a lot of times kind of people come to me and they think that their will controls all of their assets. Half the time, for us working class folks, our biggest asset is either our house or our 401ks and IRAs. And kind of the biggest mistake that I see in estate planning is failing to coordinate the beneficiary designations for your IRAs, 401ks, and life insurance policies with these fancy trusts that we set up. And so kind of the number one is you just really need to make sure that you understand that the assets are going to pass outside of probate and to the beneficiaries that you have on file with the plan administrator in the case of a 401k or the life insurance company in the case of life insurance. So that's a big one. Let's see. If I had to pick another one, let's see. How about failing to consider the estate and gift tax consequences of life insurance? A lot of times people go out and buy real expensive insurance policies, and it might be a $5 million policy that's going to push you over the estate tax exemption. You have an opportunity to actually pull that life insurance out of your estate by creating something like a life insurance trust and actually getting the whole life insurance policy out of your estate, including the death benefit. And that $5 million of death benefit doesn't have to count against you. That's another kind of big one. People make a lot of mistakes with joint accounts with a survivorship feature. One of the favorite products for a bank, for a banker, is to use a survivorship feature in a bank account. And sometimes it's with an elderly client who has 4 or 5 different kids, and they will kind of pick their child who is in town that's going to help them with their assets and just kind of paying their bills. And they don't realize that those assets actually pass by right of survivorship to the joint account holder immediately on death. And then if you have an honest kind of surviving child, they will share the balance of that account with their brothers and sisters if that was intended. But a lot of times there's a lot of surprises with respect to joint accounts with a survivorship feature, transfer on death, and payable on death accounts. And so you just need to be aware of how everything is styled, how you have it set up, and how you need to have it set up.
I got a follow-up question on that one before you get to the next one on your list. In a situation like that, where parent with their, let's just say, eldest child is helping them out, the banker titles it joint rights of survivorship, and now that child is the honest one and says, I'm going to share this, but let's say it's a big enough balance. Doesn't that create some gift tax problems potentially?
You're exactly right. And right now, the annual exclusion amount is only $17,000 per donor, per donee per year. And that means that child can actually try to distribute whatever's left over in that joint account to their brothers and sisters. But to the extent that they have to distribute more than $17,000 in any 1 year, it's going to count as a gift by them, and it's going to use up their remaining exemption that they might have earmarked for something else. They might want to use their exemption to give assets to their spouse and their kids, and not to have to try to even up the score with their brothers and sisters when mom died.
Yeah. We got time for one more, Christine. What else you got on your list?
Let's see. How about trusts that terminate early? We just talked about what happens when you give assets to kids outright, free of trust. A lot of times these old-fashioned trusts, they have these stage terminating distributions where at age 25, you get 50% of the trust, and age 35 you get the rest of the trust,
Right.
and then the trust is terminated and the assets go into or just held by the beneficiary at that time. That's an old-fashioned way of planning things, but the reality is that people can get a divorce after age 35, even if they are good with money. And kind of the new way that we like to plan is to just, instead of saying that the trust terminates at age 35, having the trust stay in place for the lifetime of the beneficiary, and then maybe at 35 allowing that kid to become the trustee of their own trust. And you can still have creditor protection associated with that trust if the trust doesn't terminate early, and it's tantamount to outright ownership. So you're actually doing your kids a favor by keeping their assets in trust.
So bottom line, here's what I'm taking away from this. If I've had a trust that was created more than 5 years ago, given all the changes that have happened with tax legislation, all the realities of life has evolved, right? I mean, divorce rates today are much different than 30, 40 years ago, maybe 40 years ago, not 30 years ago. But if it's been a while since somebody has set up a will or a trust or any kind of estate planning document or just estate planning in general, they should probably revisit that. That sound about right to you, Jack?
Yeah, I think you
and
nailed it.
especially after a liquidity event. Right? No better time than to do it at that point. Now that you got, one of the things what are the four horsemen of the apocalypse in estate planning? Creditors, the predators, outlaws, and what was the other one?
Outlaws and in-laws.
In-laws and outlaws. There you go.
Information contained in this podcast and accompanying video have been derived from sources believed to be reliable. This content is not guaranteed as to its accuracy and does not purport to be a complete analysis of the topics discussed. Analysis is based on assumptions that may not come to pass. None of the content should be construed as legal or investment advice. You should consult with a qualified professional before implementing any strategies discussed. All expressions of opinion reflect the judgment of the speakers on the date the video was recorded and are subject to change.